I have to admit I'm a little bit nervous this morning because our radio lawyer, Georgia Yanna, has come armed with a fun fact. Brace yourself. Good morning to you, Georgia.
Morning, Brett. You thought my brain was still on holidays, didn't you?
I was kind of hoping it would be because I struggled to keep up anyway. Nice to see you. Happy New Year to you.
Happy New Year.
How are things at Yanna Mann Dobson Law?
We're going great guns. We're going to have a great year. This is the 10th year of Yanna Mann Dobson.
No way, really?
Yes, so I'm planning the cocktail party and you're on the guest list.
I'll be looking for my invite. Absolutely, I will. Now, we're talking about this thing called binding financial agreements this morning. This is because you're seeing more and more blended families.
Yeah, this is what the Americans call prenups.
Prenups. I love your accent, by the
But
way.
in Australia, we call them binding financial agreements.
Okay.
And they can be a prenup, a during nup or a post-nup. This is an agreement that can be made at any stage of a relationship.
Okay.
And they are really important for blended families because, as we know, society has evolved that people are living in de facto relationships, which since 2008 they're covered under family law. They were previously under state property law, and that was really awful. So everyone in every kind of relationship's under family law. You have blended families at pretty much every generation. You could be in your 20s, your 30s, your 40s, your 50s, your 60s, your 70s, your 80s. But it's not just enough, at least where I'm seeing it from the estate planning point of view, to say, well, we've got separate assets and this is how we want to leave things to our kids. There are things called mutual will agreements, which are a whole complicated another set of things under estate law. We might talk about that another day. But the most effective way to ensure that your children from a previous relationship get what you intend them to get is that you have this binding financial agreement between the parties to a new relationship at the outset, so that what's mine is mine, what's yours is yours, and we only share things specifically designated as shared property. That's essentially what the agreement sets out.
So are you saying a will isn't enough, Georgia?
A will applies in estate law. A will applies when you die. And when you die, yes, the binding financial agreement is not necessarily enforceable. It's the enforceability of a binding financial agreement is about when a relationship ends, and yes, death ends it, but it is also very strong evidence to defend an estate law claim, to challenge a will, a family provision claim.
Is this just a way for lawyers to make money?
No. This is how you protect yourself.
Okay, I needed to ask you that. They do have a bit of a bad rap, though, don't they? Did some people question them and say, well, they're not really worth the paper they're printed on?
Yep. So
how come?
I think it's about pre-2008. Many lawyers, many generalist type lawyers would do agreements between parties to a relationship, and that was enough. But the current rules are that each party has to be represented by a lawyer. You effectively negotiate the agreement. You each get your separate certificate of legal advice, and that is what makes the agreement binding. So people go, well, this is too hard. It's very adversarial, and it just feels hard having to both have separate lawyers. And they've got to be family lawyers who want to do this, because not all family lawyers will do binding financial agreements.
Right, yeah, it must be an awkward situation. I can almost imagine the boardroom table, you and your lawyer on one side, your loved one, and their lawyer on the other. Awkward.
There may or may not be a boardroom table involved, but there is a negotiation process, essentially. Depending what you're dealing with. But, everyone's, as I say to people when we're looking at what's in their estate to, deal with in their will, everyone's estates are worth more. You've got a house that is worth more than it ever was. People have super. In that super, they may also have life insurance. Then not to mention the things they have acquired over time. They've worked. That's why I say baby boomers and Gen Xers repartnering, this is like a big deal because they've worked or accumulated wealth to a point, and then they go, well, I've separated from my first partner and now I want to maintain that for the children that we had together because maybe I'm not having more children with the next partner. That's just another level of complication. But, that's got to be taken into account, and you can't just, you have to have a binding agreement. It's not just enough to say we keep it separate.
Okay. Can we bring in your fun fact here?
Fun fact, the average life expectancy for baby boomers, hi Mum and Dad, is 2029. The tidal wave is nearer than you think.
Wow, so these are people born between 1946 and 1964. So you're saying the use-by date is 2029 for these people?
Well, I'm guessing that's somewhere along the average.
The average.
In that date range.
Thanks for cheering up the baby boomers this morning, Georgia. But really what you're talking about, we probably all jest when we see, couples that have split up get back together with other partners and you kind of go, gold digger. This is really about stamping out that opportunity.
Yes. Yeah.
So that's what the BFA
Yes.
ultimately does.
Yes, because, when it comes to divisible property, and I am not a family lawyer, there are many great family lawyers in Ballarat, but I have my, useful knowledge. When you're in a relationship, the assets that you accumulate together, and even if it's that, one is staying at home looking after the kids and the other is out working, that at-home contribution is valuable because it enables the person to go out and work, and the person who goes out to work is enabled to have a family that is looked after by the other one staying at home. So you can't just say, well, I made all that money and worked hard and did that so the person at home doesn't get it. So when we talk about the divisible assets you acquire, it's not necessarily just the house or just the things we've both got our names on. It can be the contributions of both.
Right, okay.
So divisible assets, it's not just as easy.
Yeah,
and so
complex.
you accumulate in these, in your younger years, you're obviously accumulating wealth and assets and things. But then when you sort of got what you've got, and especially after a relationship breakup, people tend to want to maintain what they got away from this next relationship. And second relationships have a higher rate of failure than first ones.
Yeah, okay. Can I ask you a side point on this? And this is a bit of a personal question.
Looking for some free legal advice,
Yes,
Brett.
that's exactly what I'm doing this morning, Georgia. So my youngest daughter shacked up with her boyfriend just recently, okay? Got a nice little flat.
FYI, Ballarat.
But they're buying all their stuff, They've bought the fridge and the washing machine and the couch and the microwave. She's bought that, he's bought this.
Divisible assets.
Yeah, so what should they be doing to protect themselves?
Binding financial agreement.
Even as a 21-year-old,
Yes.
you'd recommend it?
Well, would I recommend it? That is the solution. The thing is, people don't do it because they go, well, we've got chattels like goods to divide.
Yep.
But then you've got 21-year-olds, 22-year-olds, whatever, who build houses together, and that is a divisible asset. If one contributes more because they had greater savings, because maybe they started work early, they might have done an apprenticeship or whatever it is, and so they've got more money behind them, or they've got parents who've got money behind them. The parents need to do things to protect themselves, and that's where parents loan money, and they generally can't put a mortgage on it if there's borrowings from the bank, but there'll be some loan agreement in the background there, because otherwise that's an important one. When parents lend money to kids, if it's not properly documented, there's a presumption of advancement that a parent would give money to a child, no strings attached.
Really?
Yeah.
So as in not going to
so
pay
unless
back?
you put those strings in writing,
Wow.
it's presumed you were wanting to advance your child's position, and it may become part of the divisible assets if that's not documented properly.
So verbal is just a complete waste of time if it's not written down,
you can't
not
rely on
documented.
any
No.
verbal stuff, basically.
Yeah, okay. What about inheritances? Are they at risk if a BFA is not in place?
So, as the child of a parent who has repartnered, yes, because as soon as your parent repartners, that new partner, it works both ways, they start to accrue rights against each other under estate law, so that if one dies, but for the fact the person died, they would have still been able to live in that person's house or do whatever. So that's where in estate law we make certain plans for, we might put things in trusts or we might give a life interest, but then sometimes that's also not enough. Because it may be that the surviving spouse, depending on the length of the relationship, should be entitled to, to have more than a life interest in that house. So it's quite complicated, and there's various strategies. There's no one size fits all for blended families, and blended families are everywhere these days. It's not just if I get a straight first relationship, got kids, getting on, like that's,
Yeah,
that's
it's like a unicorn.
It's like a unicorn.
Wow, okay, that is rare. And if there is no BFA and we're looking at assets of both parties, that's where the family court could get involved and actually make the decisions, I guess.
So
no?
the family court is, you're only going to come under family law if the relationship ends while you are alive.
Okay,
Right?
okay.
So let's run it through. You separate or your partner dies, you repartner, so at least second relationship. Could be third, could be fourth, could be fifth, whatever, same. You're in a next relationship. From the outset, you should consider putting in place a binding financial agreement under family law, because that's what applies while you're alive, so that in the event the relationship ends while you're alive, then you've got a document saying what happens. If one dies, then depending on length of the relationship, all the facts of the case, we could potentially, depending what the will provides for, if, say, the will provided for everything to go to the children of the first relationship and nothing much for the spouse, that spouse could challenge the will. But the binding financial agreement can be strong evidence to defend that, no, you guys made an agreement while you were both alive with, full capacity and knowledge of things, and depending on the length of time, that may still be binding, and that may help to defeat a challenge to the estate so that the wishes expressed in the will hold tight.
Boy, I need a cup of tea and a little lie down after our discussion this morning, Georgia. Overall, though, you're saying BFAs work, but you need to make the deal a reasonable one.
Yeah. Yep, and comply with the technicalities. They fail when you don't comply with the technicalities. You both don't get the proper advice. You do a DIY agreement. This is not a DIY job at all. Literally, the legislation says you've got to have certificates of advice for each party for it to be binding.
I reckon there'll be a workaround for lawyers for just a little bit longer after our chat today. Dress code for your 10th birthday cocktail party, just so I can get some advanced planning done.
Oh, I do think a frilly cocktail frock would be right up your strasser.
Might not be available. Georgiana, thanks for your time on the show.
Thanks, bye.